Have you called for public comment on item 3?
Good morning. Today is Tuesday, May 7th, 2024. And welcome to today's meeting of the Law and Policy Committee of the California Fair Political Practices Commission. Ms. Linker, will you please take roll?
Baker. Chair Silver.
Here. Okay, great. Well, why don't we move on to item 1? And that's going to be public comment for items not on today's agenda. Seeing and hearing no public comment, let's move on to item 2, and that's going to be approval of the April 2024 minutes. Ms. Baker, do you have any?
No comments or additions. Move to approve. Thank
Excellent.
you.
Second.
Chair Baker.
Aye.
Chair
Aye as
Silver.
well. We should also, if there's any public comment on that item? No? Okay. Seeing and hearing none, we'll move on to item number 3. And that's going to be a presentation by our General Counsel, Dave Bainbridge, the Statement of Economic Interest in Citizens Oversight Committees. Thank you, Mr. Bainbridge.
Good morning. I have a slideshow here for us that will also be available on our website when the meeting is over for anyone who's interested in taking a look at it, or they can just watch this video. All right, so the question that we're looking at today is whether Citizens Bond Oversight Committee members are required to file an SEI by the Political Reform Act. This question came about as a result of public comment at a law and policy meeting a couple months back. We have not received an advice request on this question, which would be the typical process by which this would come to us, but this time we're instead giving a presentation that is a general presentation about bond oversight committees. It's not regarding any specific school district or oversight committee. It's based on what the statutory duties are of these committees and the members of them. So for this presentation, I'm going to go through some background on what the bond oversight committees are. I'll also go through the basics of the SEI filing requirements, and then take a look at whether the bond oversight committee members should be filing based on the SEI filing requirements. All right, Citizens Bond Oversight Committees resulted from a ballot measure, Prop 37, back in 2000. Excuse me just a second. That measure lowered the voter approval threshold for approving the issuance of school bonds. And as part of a countermeasure to that lowering of the voter threshold, it required the creation of the bond oversight committees so that any school district that wanted to issue bonds would need to create a bond oversight committee. Bond oversight committees are made up of members who are citizens within that school district. It's a volunteer position. Typically, the committees they're required to have at least 7 members. And then the members are required to come from certain criteria. So that, for example, there needs to be one member who's an active member in a business organization within the district, one that's an active member in senior citizen organization, parents and or students if it's a community college. Certain people are prohibited from being bond oversight committee members. That includes school officials, employees, and contractors with school districts that are creating the bond oversight committees for obvious reasons. They may have a strong personal or financial interest in the bonds. So they are prohibited from being on the bond committees. Also, you'll see in this is the statute from the Education Code providing that. There are some safeguards put in place. So members of the Citizens Oversight Committees are subject to 1090 restrictions, so prevented from having financial interests in any contracts resulting from the bond act, the issuance of bonds. And then also the incompatible activities requirements that state employees are subject to as well. All right, so here is the stated statutory purpose of a bond committee. I'll pause and let people take a look at that. So as you can see, the duty of the bond committees is to monitor how funds are spent from the bond proceeds and to inform the public of how the elected officials are spending that money. Specifically, what are the activities or the duties of the bond oversight committees? And this again comes from the education code that creates the bond oversight committees. It's a list of what their different activities are that they may participate in overseeing the spending of bond funds. I'd summarize it as receive, review, inspect, and report. They have various rights to receive information, inspect facilities, and then review different documents and report on what they found. You'll note they don't perform duties for the school district. They don't report to the school district, and they don't have any authority over the school districts. They don't have any governmental decision-making authority. They really are designed to be a conduit of information to the public. Okay, so that's a little bit about the bond oversight committees. Now we look at, that didn't advance, did it? All right, so turning to the Act. This is who files an SEI, a Statement of Economic Interest. There's two categories of filers. There's what we call statutory filers, found in Section 87-200. Those are public officials who are explicitly listed in the statute as being required to file a Statement of Economic Interest. They make up the minority of people who file SEIs. The larger group are what we call code filers under Section 87-300. These are agency officials, officer, employee, member, or consultant that are designated in an agency's conflict of interest code as being required to file a Statement of Economic Interest. They're known as designated employees. So how does someone, what qualifies someone as a designated employee? The agency for which they are an employee, and when we say employee, we mean in a broader term. It doesn't have to be someone who's paid a salary. It can be volunteer positions, elected officials, those sort of things. So it's to be a designated employee, the agency has to determine that this person makes or participates in making decisions where they could potentially have a financial interest. It's the duty of the agency to go through all of the different positions at their agency and determine who makes or participates in decisions that could result in benefiting them financially. If they determine that someone falls into that category, then they're a designated official. They have to be identified in the code. The code will identify what financial interests they have to report, and they'll be required to file an SEI. So it's important to look at what the definition of making a decision is. And it's the language, the specific language from the regulation is there. It's essentially authorizing, voting, committing to action. When we say voting, it doesn't have to be the decision that actually causes the action. So you could vote and not win the vote, but the act of voting itself is considered making a decision under the Act. The other standard is participates in a governmental decision. So this isn't necessarily making the decision, but it is providing information, an opinion, a recommendation to the decision maker for the purpose of effecting the decision without significant intervening substantive review. Meaning, if what we call this kind of the rubber stamping standard, if someone's recommendations are routinely taken, that action is taken based on those recommendations without much review from the governing body, that's considered without significant intervening substantive review. So those are the two categories: makes or participates. A designated employee, by definition, there's an exception that an unsalaried member of any board or commission which serves only solely an advisory function is not considered a designated employee, in which circumstance the members of that advisory board or committee would not be required to file an SEI because they, by definition, do not have the ability to make or participate in governmental decisions. All right, so now we have what the CBOC members do. We have what the standard is. We apply the facts to the law. In looking at analyzing this, we looked at what the statutory requirements are for a CBOC. We didn't look at any particular CBOC or how it operates. We're simply looking at what their statutory duties are. In looking at it, we determined they don't make any decisions. They don't authorize, direct any action. Similarly, they don't participate in decisions as they don't provide information, an opinion, a recommendation for the purposes of affecting governmental decisions. Their role is really to review materials, make reports, and provide that information to the public. They don't have, by statute, any interplay with the governmental entity itself. They're essentially a watchdog that's providing information to the public. Based on this analysis, our determination is that from a statutory standpoint, the CBOC members should not be required to file a statement of economic interest under the Act.
Breakdown of the law, Mr. Bainbridge. A couple questions for you. Has the AG's office ever advised on whether these types of bodies are subject to the Form 700 filing? I should say they're employees or members.
Yeah, our research didn't find any opinions from the AG's office on this.
And is it common for school districts to consider the findings of these bodies in making decisions?
I don't know. I would assume. I would assume they pay attention to them. They're not intended as that. They're intended as a check to provide information to the public. I think, if I had to guess, the thinking was if we're going to lower the voting threshold from 2/3 to, I forget, 55% or whatever it was, this was a way to have to not lose the oversight of the public, in that they would be provided this information by a government board.
That's all the questions that I had. Commissioner Baker, do you have any questions?
Thank you for the good questions, Mr. Chair. I do have some as well. Perhaps following up on the most recent question, were you able to find, I think there's something like 900 school districts in the state of California, 900 to 1,000, excuse me. So did your research include finding any local school districts that have on their own chosen to require Form 700, even if it's not required by the statute provisions you've provided?
Yes, we did.
And what did you find?
Well, we did a survey and found, in looking online, which may be sort of the fact that they have it online may kind of be a self-selecting group, but of 17 surveyed, we found 14 that had adopted or had required their members to file an SEI.
In that if you reached out to the California School Boards Association, they might be a source of, they might even have more information on the prevalence of that, just because they might have it at their fingertips. I don't know.
Yeah, I don't know if the attorney who researched this had contacted them or not.
Okay.
There is a
yeah.
California Bond Oversight Committee organization that we had taken a look at their website and obtained some information from.
Good. If there is any follow-up on this, and we may decide that today or in full commission, they might be a source of information as well. But so my other questions go to earlier in your presentation. It's the title slide, CBOC duties: receive, review, inspect, report. A couple of the items that you list, items 5C and E, say that part of what they do is make recommendations regarding the cost-effective use and efficient use of facilities, recommendations regarding joint use of core facilities, which I would like you to comment on how that jives with the idea that they're not making recommendations to a governmental body, they're just reporting.
Yeah, I think it's because their recommendations are for public information. It's not to the. It's sort of indirectly to the government agency. They're saying this is how the money should be spent, but it's not a recommendation for the purposes of directly influencing a governmental decision. When we talk about that, we're talking about staff who has a role within an agency to recommend decisions that be made. In my mind, this is much more attenuated in that they're not making the recommendation to the agency. It's more of a report to the citizens. It's kind of an indirect recommendation, but I think there's a distinction to be made about whether if it's for the purposes of influencing governmental decision, because that's not one of their duties to advise the governmental agencies.
To me, it sounds like a pretty fine line, and I want to understand better how the team has reached the conclusion it is more attenuated, because it looks like it's a direct quote from the Ed Code that recommendations regarding the use of core facilities and recommendations regarding facility plans. Are you saying it's because that's a relatively small responsibility they have? Or in practice, can you just elaborate on that? Because I'm seeing the statute and I just want to understand better how we've gotten to it's a more attenuated point.
Well, because the recommendation isn't actually going to the government agency. They don't have any, the way they're set up, their job is to report to the public about what the government agency is doing.
Okay.
I can see why phrasing it as a recommendation can look that way, but I think when you look back at what their main purpose is and their duties are, it's all focused on reporting out what they're finding and providing information to the voters.
To the public. So the idea is, because they're reporting to the public broadly, it's not so much a recommendation to the school district, the school board.
Right.
It'd be pretty hard to believe that the school board would ignore that or not see it as recommendations, but I get it. Okay. And also on the standard under the slide, designated employee standard, I think it's important to understand, because you're really making the distinction about who's subject to a Form 700. Bullet point 3, you talked a bit about the significant intervening substantive review. As a lawyer, I really don't know how else to ask this. Is that an objective standard, or is it the individual school district? Let's say in practice, a school district effectively takes that public report and that school district could be a big one like Los Angeles. It could be a small one in a more rural part of California, is taking that as recommendations and using that very much so. Is that the standard, or is it more objectified? Help me out on that one.
When we interpret this term in other contexts, because this comes up in the conflicts context too, you really look at the specifics of the situation, and really the question is, are they almost because of how much is their role in making the decision of this entity? How much of it is we provide the information and then the board or committee makes decisions independent of it. So for example, if you had a planning commission, staff may recommend certain decisions constantly, and some of the time the planning commission goes along with staff's recommendations, some of the time they don't. In those sort of circumstances, you would say that's significant intervening substantive review, based on the fact that they aren't just taking the recommendation of what the staff says all the time. In other situations, you'll see it's really just the assistant deputy makes a recommendation, and the person above them just signs off on it in every circumstance. You've seen, often with contracts, the person who has to sign the contract isn't reviewing them very closely. You could see a pattern of having never rejected a contract suggestion, that sort of thing.
Okay.
That's the sort of thing where we would say there wasn't significant intervening review.
Gotcha. And I think I only have two more. One is, can you say more about so there's what it looks like on paper and then what the actual practice is? I think you mentioned 18, was it 18 school districts, or you might have looked at some. Can you say more about how in the work that you've done, your team's done here, they looked at what's practically happening on the ground, and elaborate on that a little bit more, please?
We didn't find much information on how individual districts or the board oversight committees actually operate. My sense is that early on when these started, people adopted included the positions in the codes as maybe in an abundance of caution, or just assumed, well, this is a new committee we've created. We need to put them in our code, without understanding that this would act as an advisory board and wouldn't need to be included in the code. So that's my sense. I don't know how each one operates, or how differently they operate, or how far they deviate from what the statute provides for what them to do.
And then finally, am I correct that there's nothing to stop a local school district when they do these measures of requiring Form 700? And nothing to stop now the public in a local jurisdiction to go and request it because it's part of their conflict of interest code? Or would they have to repass the bond measure that authorized the bond entity?
So the question is requiring the local agency to have the bond oversight committee members
I'll
file?
try it again. So if someone came away from this and said, gee, our school district doesn't require Form 700 for our bond oversight committee, and it should, is that person's avenue to try to change that going to the school district, and the school district just has to pass something, maybe adopting their conflict of interest code, modifying it, or because the bond oversight committee was created by, we have some statutory provisions here. Is there some other way, maybe state law? How else would they change it?
Yeah, that's a complicated question. I think the best way would be to get a statutory change that places a requirement that board members file SEIs. I say that because if they don't meet this standard, they can't. Someone who was on a committee could challenge the requirement that they file an SEI. They could go to the agency and say they need to be filing SEIs. If the agency made that determination, if they're just following what is required by statute, a member of the bond oversight committee could challenge whether they should be included in the code. That would then be a factual analysis of whether these committees have duties that would then require them to file SEIs. So I would say the first step would be to approach the agency, and if the agency has created additional duties for these bond oversight committees that push it beyond being an advisory body, and they are making governmental decisions or influencing governmental decisions, it may be the case that they would need to file, but that would be a case-by-case basis on what the duties of the bond oversight committee members are.
Mm-hmm. And what would be our authority in that? You're recommending they make a statutory change. Is there something, if we decided to, and I'm not saying we are, would the FPPC have authority to require these citizen bond oversight committees to have a Form 700 filer? No,
we don't have an avenue for doing that.
All right. Thank you. Thank you, Mr. Chair, for the time to ask the questions.
Thank you. And just to follow up on that question, what agencies do we have authority over in terms of forcing them to adopt a conflict of interest code where it's appropriate?
The agencies where we are the code reviewing body, and this is something I will get into in more detail at the May Commission meeting. I'm going to give a presentation, Suki Brar and I, on the code adoption process overall and how that works, and how people in the public or employees who maybe disagree with the categorization of a particular employee can challenge the code. It's typically through the agency that adopted the code, and then what's called their code reviewing body is sort of the level of appeal where you would go, and then after that you can go to the Superior Court. But I plan to provide more information about that process at the commission meeting. So in terms of our role, it's when we are the code reviewing body where we may have some role in the process. But when it's local agencies where we're not the code reviewing body, which we're not the code reviewing body for most local agencies, the process is through the agency itself and then their code reviewing body. And then if you don't like the result there, the next step is going to the Superior Court.
Okay, and since I see we have some public comment on this, I think it'd be helpful to flush it out a little bit further. So let's say, going back to the conversation of recommendations, there is this exception for unsalaried members of any board or commission which serves as solely advisory function. Could that type of member in that situation still provide a recommendation? And would that result in the body not being considered an advisory function? Essentially, could a member of what is considered an advisory board make a recommendation to a government agency or to the public? And if we don't have an answer for that today, I know we have another presentation coming up later this month, so we can definitely defer to that meeting as well.
Well, when we talk about what the purpose of the advisory or the purpose of the board is and whether it's advisory, we look at what their authority is. Whether an individual could somehow participate in a decision, we can't look at it from that perspective. We have to look at it from what the authority of the agency is, and we designate it as advisory based on that. If what we see is that over time they've consistently gone beyond what their authority is under the law, whether it's statutory or a local ordinance or whatever, then an agency could go from being an advisory one to one that has decision-making authority. But it starts with what their legal authority is as an agency, not really what the individuals attempt to do.
And our research indicates that these types of bodies are advisory bodies.
Yes, based on what their statutory duties and obligations are.
Okay. So even if they were making recommendations pursuant to the statutory provisions, they'd likely be exempt from filing under this provision.
Yeah, I don't think if they're performing the duties laid out in the statute that they are going to qualify as making or participating in decisions. So at most they'd be an advisory board and they'd fall under this exception of not being designated employees.
Okay. And generally I like to err on the side of caution when it comes to transparency. So I appreciate that we have these bodies who've adopted codes themselves and required their members to disclose. But what criteria do bodies have to consider when deciding whether or not to adopt a code? Are there First Amendment concerns by adopting a code and requiring people to file where they're not required to file by law?
Yeah, individuals have privacy rights. There's case law in this area that there needs to be a nexus between what you're requiring them to disclose in terms of their financial interests and the position they have, which is why we look at whether that it's foreseeable that a decision would have a material financial effect on their finances. If it's not foreseeable, requiring them to disclose their financial interests can go beyond their right to privacy. So there has to be a reason and some sort of likelihood that a conflict could occur before you can require someone, even a public official, to have to disclose financial interests, which is why codes are done at the local level and by the agencies who know what decisions these officials are going to be making, and they're relied on to identify when a financial interest could arise, and so that the codes are tailored to the individual positions. You don't just require everyone to disclose all of their financial information.
Right. So even if the code was adopted, their economic interests in general would be limited just to interests that would be impacted by the decisions that they're participating in, to the extent that that's the case.
Right.
Okay. I think that's it for me. I know we have, do we have any public comment, Sasha? Okay. Go ahead. Public comment. Hello?
Hello, shall I proceed? My name's Missy. Am I the first speaker?
You are. Go ahead.
Yes. Thank you for this opportunity. Say, thanks very much for doing the presentation first, because I'm able to provide some different comments. Let me introduce myself as a new member of the Citizens Bond Oversight Committee for my local community college in LA County. Specific to your presentation is that the committee members in our CBOC vote as a committee, differing votes, but typically all affirm the auditor's report. That then goes to the Board of Trustees, who then does the formal and final acceptance of the Citizens Bond Oversight Report. That's done in a public meeting. Secondarily, to your point, for the public, my understanding is that, and what I've seen, is the Oversight Committee, typically the chair of the CBOC, issues a report. It's brief, it's a summary. It says, hey, the CBOC committee approved the auditor's report, onward we go, etc. I understand specifically for us as committee members, we do not have the right to speak on behalf of the committee at any time. That's really the chairperson's right. And so it's not, from my understanding, the practice and my observations prior to becoming a committee member, it's not as if there's a lot of interaction between the Citizens Bond Oversight and the public. The public can come to the meetings, they're open meetings. However, that's usually a small representation of the public. So just to clarify, as a member of both the public and the committee, I don't hesitate in if I were to be required to disclose my employer and perhaps any, as you spoke about, any specific type of things, whether it's voluntary on the part of my community college or voluntary on the part of the Citizens Bond Oversight. I think that's one way for community members to get to understand the nature of the expertise of the Citizens Bond Oversight. So again, I'm honored to be part of the Oversight Committee, and I look forward to, participating in that fully. And I thank you for this forum.
Well, thank you for that comment. We greatly appreciate participating today. Sasha, do we have any additional comment? Go ahead. Good morning. Okay. Sir, it appears you're on mute. If you'd like to make public comment, just go ahead and unmute yourself. Do we have any additional public comment beyond that, Ms. Linker? Okay. One last question before we consider a motion or move on. Who is the code reviewing body for these committees, or it varies depending on the location of the committee?
Yeah, it depends. It depends on whether they are in multiple jurisdictions or just one jurisdiction. Typically, if they're within a city, it'll be the city. If they're within a county, they'll be the county. And if they span multiple counties, it'll be the FEPC.
Okay. And then I think it'd be helpful at the commission meeting when we discuss this, if we could take a look and see if civil grand juries are subject to Form 700 disclosure, participants on those juries. Sounds like they serve a similar purpose, inspecting, reviewing information, providing a report to the public. So I'd be interested to see how those are treated. So, Commissioner Baker, would you like to make a motion or move on?
I don't have a motion. I did have a vote. There we go. It's a new button, so getting used to it. We've talked about school districts, and of course there are bonds that can be, for other things, health care related, general budget spending for a county, transportation bonds. Was there you particularly focused on school districts because I think that's how it originally came to us. Is the report that you're preparing for May broader? And if not, can you comment on how much these rules apply to other types of bond oversight committees that are not school district related?
Yeah, the presentation in a couple weeks will be much broader. In terms of other bond oversight entities, we did do some research into those, and it just depends on how those committees operate, what their authority is. So it's a case by case. we have given some advice regarding other types of bond oversight committees in the past, and we looked at it, but it doesn't really make sense to compare it because they have different statutory duties and obligations.
Thank you. I've understood this as an informational program. I don't personally have a motion. I'm going to digest it a little bit, and knowing that ultimately it sounds to me that there's some advocacy individuals can do within their local jurisdictions, which frankly is almost always better because you can tailor your local circumstances to who's involved and your specific community, or a statutory change at the state level. And I think, if a time comes that we feel it's necessary to pursue that, and I think there's more reports coming to us, that might be something to consider for future legislative action another time. But those are my thoughts without a motion for anything. Thank you, Mr. Chair.
Thank you, Commissioner Baker. I guess I'll give one more opportunity for public comment. Okay. He call in on the phone? Is that an alternative? Okay. Be able to move on and then come back once we figure out how to get him live? Okay, excellent. Well, why don't we move on to item 4, legislative update with our senior legislative counsel, Lindsay Nakano. Good morning, Ms. Nakano.
Good morning, Chair Silver, Commissioner Baker. Nice to see you. All right. There are 21 active bills. The report now includes the Commission's costs for all of the bills. I'll go over that information and some updates today. Starting with AB 1170 by Assemblymember Valencia relating to electronic filing of Form 700s for certain individuals. That bill is now in the Senate. It was double referred to the Senate Elections Committee and the Senate Judiciary Committee. The Commission's costs are minor and absorbable. AB 2001 by Assemblymember Gallagher relating to minor changes and cleanup in the Political Reform Act. That bill is also in the Senate. It was referred to the Senate Elections Committee, also has minor and absorbable costs for the Commission.
Ms. Nakano.
Mm-hmm.
Quick question on the Valencia filing bill. Did that go to Assembly Judiciary? And if not, what was the basis for sending it to Senate Judiciary?
I don't believe it went to the Assembly Judiciary Committee. My general understanding is that the Senate Judiciary Committee is a little bit more inclusive in what they like to pull in. I don't have specific information on why it was pulled in, but my guess would be is that because it affects the Form 700s of certain people in the judiciary, that might be why they pulled it in. But I can get some confirmation on that.
Thank you.
All right, moving on, AB 2631, Assemblymember Mike Fong. This relates to the Commission's local ethics training program. That bill is still on suspense. The suspense hearing is May 16th. The costs include one position in the IT unit and education software for that program. SB 1027 by Senator Menjivar. This is relating to redaction of bank account information on statements of organization. That bill is in the Assembly. It's waiting for referral to committee. Costs on that are minor and absorbable. SB 1404, Senator Glazer. This relates to the lobbying audit program and a new lobbyist fee. That bill is also on suspense in the Senate Appropriations Committee. Our costs are 6 to 7 positions in the audit division. Because there is a fee in the bill this year, the fee is projected to cover most of the costs of the program, but not all of them. There's a gap of about $200,000 to $300,000. Staff are determining whether there are ways we can lower that cost while also ensuring appropriate oversight and accountability. That's a work in progress, and I'll keep the Commission updated.
Excellent. Commissioner Baker?
And is that an annual? It's not a one-time gap?
Yes, that would be
Okay,
annual.
got it. Thank you.
And I just have a follow-up comment. I wanted to highlight some excellent work that our audit division just completed. That's published in our executive staff report for the audit division. They just completed a discretionary audit of 5 different lobbying entities, and it's my understanding that we found material violations of the lobbying rules in 4 of those 5 audits, which just goes to show the necessity of this bill right here. So just wanted to highlight that for the public. If the public would like to learn more about that, they can take a look at the executive staff report that's on this month's commission agenda. I know that there were some questions raised as to whether or not it was necessary to even do these reports, because there may not be any indication that there are violations of the lobbying rules, but clearly, that's not the case based on these results. Any other comment on this one, Commissioner Baker?
Jerry, you said that very well, and I appreciate the team for doing that. I'm glad we did that, and just want to underscore, we've had so many significant matters that go to the heart of public trust and integrity and the use of campaign funds that have only come to light because of the audit. And we have a robust and independent, I would say independent, so it's separate from our enforcement team, audit structure. We made that reform a few years ago. And what you've just found, 4 out of 5 had material violations, just goes to the importance of these audits. And I strongly hope this bill happens. I know whenever there's a cost gap, there's question marks, particularly so when there are budget deficit conditions that we're going to see with the May revise. And I just believe government finds a way when they really make something a priority. And I think this is one of those instances where it needs to be. And if we wait until there's a year where the state's flush with cash again, money's probably not going to come our way for this. We just got to do it. And I hope that the efforts with the author will be fruitful in getting this. And I think if there's anything more we can do, we'll look for your recommendations on how we can make that go forward. So that's my soapbox. Thanks for giving me the opportunity.
Box on this one. You can go ahead, Ms. Nakano.
Thank you for that feedback. All right, I'll move on to other commission-related bills, starting with AB 2041 by Assemblymember Bonta. This relates to the use of campaign funds for security expenses. That bill did pass in the Assembly. It's in the Senate. The costs are minor and absorbable. AB 2573 by Assemblymember Mike Fong, relating to the services of a fellow and whether that constitutes a gift under the Political Reform Act. That bill was amended just yesterday to be broadened to provide that the services of a fellow provided by a 501c3 nonprofit to a state agency for purposes of assisting with official state agency business does not constitute a gift under the PRA. There was a question about ensuring that the bill, if expanded, was appropriately inclusive and included colleges and universities. Most public and private colleges are 501c3 nonprofits, including the UCs and the CSUs and private colleges. Other organizations that have asked for advice from the FPPC on this subject have been 501c3 nonprofits. So from our research and experience at this point, we think that the 501c3 measure is an appropriate way to make this bill inclusive, but we're open to any feedback or thoughts on that.
Thank you. Thank you for that update. And I'm glad that this is proceeding. It's become more clear in that regard so that we don't have just one particular type of fellow mentioned. The conspiracy theorist in my mind is also looking for ways in which it might be abused. And certainly if a elected official requested a fellow from a nonprofit, and that is maybe a paid fellow that is more than $5,000 in I can't remember if it's 12 months or calendar year, but I think it's calendar year. Someone could nod and help me for behesting purposes. Would that still be subject to the behest? Or if they're not reported as a gift, there's no other way of knowing if a nonprofit is providing a paid fellow to a legislative office. Can you comment on that, or perhaps that may be a question that gets booted to Mr. Bainbridge?
I believe the behested payment reporting requirements would apply, but I defer to our general counsel on that.
Okay.
Yeah, that's correct. That's what we've advised in the past, that if it is made at the behest of an official, it would be a behest.
Okay. And would there, thank you, would there be, if it's not behested, but it's just offered, is there any other way the fellow being provided to the legislator would be, I'm saying legislator here, would be made available to the public? There's no other way unless it's a behest?
Not to my knowledge.
Okay. I don't know, of what the potential areas for abuse would be. I'm not seeing them here. And it sounds like we already have some, we've actually kind of weighed in on this before where it may not be necessary to even have this legislation. I may be wrong. So it may not be a dramatic change. But if in the conversations as you continue to see this bill go forward, if we just take a pause to make sure we're looking and considering any potential areas of abuse that this might open up, and if people smarter than I am come up with those, what we might want to do to just keep that in mind before the bill gets enacted. Thank you.
Those are great points. I'm a little concerned. I appreciate that we're expanding this to 501c3s, right? But my understanding, based on the conversation we just had about the law, the relevant law, is that even if this was a C4, it still wouldn't be a gift. If it was a C5, it wouldn't be a gift. So again, going to your point, it doesn't seem like it's necessary to have this legislation in the first place. So I don't know if that's something that the author's office has commented on, but I'm concerned that if we say C3, it gives the implication that perhaps fellows provided by other entities, their services would constitute a gift to a state agency, where that would not be the case based on the advice that we've provided.
Thank you for that. We can look more into that concern. All right, I'll move on. AB 2654 by Assemblymember Vince Fong. This was a short-lived bill. It's actually not in the report because it lived and died between reports. That one was heard in the Assembly Elections Committee. It did not pass. The vote was 2-1 with 5 not voting. So that bill will no longer appear or be presented to you this year. AB 2803 by Assemblymember Valencia. This bill relates to the. Oh, yes.
I'm
please.
sorry, Mr. Khan. Just to be clear, that was a bill related to NDAs?
Yes, yes.
Okay, I
Apologies.
didn't fill
yes.
that little part in. Thank you.
All right. AB 2803, Assemblymember Valencia. This relates to the use of campaign funds for legal defense for certain criminal convictions. That bill is set for hearing in the Assembly Appropriations Committee. It's one of 2 that has not yet been heard in appropriations. It's set for tomorrow. That bill has, from us, minor and absorbable costs. AB 2990 by Assemblymember Lowe. This relates to the statute of limitations for FPPC enforcement actions. That bill is also set for hearing in the Assembly Appropriations Committee tomorrow. FPPC does have very significant costs on this bill. Mostly in the enforcement division, 17 to 20 positions in the enforcement division, 2 positions in the legal division, 1 to 2 positions in the audit division, and 1 position in the administration division. We anticipate very significant effects on the ability of the enforcement division to do their work and how they conduct their work, and that's reflected in our fiscal. All right, moving on. Unless there are any comments? Nope. Okay. AB 3239 by Assemblymember Carrillo. This relates to the use of campaign funds for emotional support animals in airline travel. That bill passed in the Assembly, and our costs are minor and absorbable. Yes.
A question about this one. If that is something you might be able to reach out to the author diplomatically. Is this something that the author has personal experience with? And I'm not looking for revealing anything personal about the author, but have they or their staff, without revealing identities, what's the firsthand experience that potentially, if any, that brought this forward? Or was this, what was the inception of this? To know a little bit more about that. since it came late in our legislative process, as I recall, in this cycle, 2-year legislative cycle, because I'd like to know if there was a particular issue where somebody couldn't bring a support animal unless they had campaign funds to do it. Thank you.
Thank you. I'll look into that further. Moving on to SB 948 by Senator Limon. This relates to the transfer of campaign funds if a candidate does not run in the general election. The bill was amended to include both of the scenarios that were covered in the regulation project. That bill passed in the Senate Elections Committee on April 30th, 7-0. It's now on the Senate floor. Our costs on that are minor and absorbable. SB 1111 by Senator Min. This relates to a new remote interest for the financial interests of certain family members and their spouses, and this is in the area of Section 1090 relating to conflicts in government contracts. That bill is on suspense in the Senate Appropriations Committee. We had a half position in the legal division for a projected increase in advice. It's not, from my experience, half positions are not always reported in the Appropriations Committee. It appears that it depends on the consultant and their judgment on whether it's significant. In this case, a half position for an attorney was about $90,000, and in Senate Appropriations, that reaches the threshold for the suspense calendar, so that bill is on suspense. SB 1151 by Senator Hurtado. This relates to registration and reporting requirements for foreign agents. That bill is also on suspense. The FPPC has costs one position in the legal division and one position in the enforcement division. SB 1155, also by Senator Hurtado, relating to a post-governmental employment restriction for former heads of state administrative agencies. That bill is on the Senate floor. The costs are minor and absorbable. The last bill from Senator Hurtado, SB 1156, relating to financial disclosures for groundwater sustainability agencies. That bill is headed to the Senate floor. We have minimal costs, $20,000 to $40,000 annually for the costs of expanding the filer capacity of the Commission's electronic filing system. SB 1170 by Senator Menjivar. This relates to the use of campaign funds for mental health expenses. This is the only one we have a kind of TBD, to be determined, cost on. There are pending amendments, and depending on how that might affect our enforcement division or otherwise, there possibly could be costs. Staff is continuing to work with the author's office and sponsors on technical amendments to that bill. I expect that if those happen, they will happen in the next week or so. SB 1422 by Senator Allen. This relates to disclosures for paid travel by elected state officials. That bill is also on suspense. The Commission has costs for one position in the enforcement division. SB 1476 by Senator Blake Spear. This bill is on the Senate floor, and the Commission's costs are minor and absorbable. Last, we have the three Section 84308 bills. AB 2911 by Assemblymember McKinner. That bill is on the Assembly floor. The author stated in the Assembly Elections Committee that she would work with opposition, including Common Cause, on lowering the contribution limit from $1,500, which it currently is in the bill. If those amendments will happen, I would also expect those to probably happen by the end of this week. The Commission's costs on that one are minor and absorbable. And I'll point out that Common Cause had submitted a comment letter relating to their thoughts on all three of these bills. SB 1181 by Senator Glazer. This bill currently only includes an agenda notice requirement. The author's office shared this morning that they are considering taking 4 amendments. I'll describe those for the Commission. The first is exempting contracts between 2 or more government agencies. I think the thought there is that there's unlikely to be a conflict or personal financial interest involved when it's relating to 2 agencies. Exempting contracts with no reasonably foreseeable financial effect on either party. exempting modifications of amendments to or renewals of all contracts that are exempt under the Levine Act. So if the contract is already exempt, renewals and modifications would also be exempt. And last, defining competitively bid contracts to mean contracts awarded following a competitive process, which seems straightforward. Staff would consider these changes reasonable, and Senator Glazer's office is interested to hear if the Commission has any feedback or concerns about those proposed changes.
I didn't hear anything related to the contribution limit. Is there any consideration of raising that limit from 250 to a higher number?
Not at the moment. If the Commission would like to provide some feedback on that, I'd be happy to share that.
And how do those changes differ from the changes in the Dodd bill, for example?
It's my understanding, having seen them today, that they are different. All of them are different, covering different subjects, different areas. So it's, I think, addressing some of the concerns that have come up from some local agencies. Other local agencies brought up other concerns, and those are addressed in the Dodd bill and otherwise.
Do we have any idea? I know we just got these, sounds like last night or this morning. Do we have any idea how the proponents of the legislation that Mr. Glazer passed last year, how they feel about these changes, as well as the opponents who are in support of Mr. Dodd's bill?
It's my understanding that the author's office has been working specifically with Common Cause on these amendments since they were the proponents of the, as you said, the bill from 2 years ago, and have been very involved with this area. I don't know that they have engaged the proponents of Senator Dodd's bill or other opposition from the prior bill, but I can ask him if those conversations have occurred.
Mr. Chair, one of the 4 amendments that you mentioned, I have some questions about, and I think it's the one that if it's already a contract that's been approved and you want to modify it or renew it, are we generally talking about labor contracts? Do we have a sense, just for the practical purposes, what type of contracts are most likely to fall within that frame? That would be my first question. And the second is, and it all comes down to language, is it really any modification? Because that's that could potentially be a big waiver of application. Those would be my 2.
Thank you. For the first question regarding what kind of contracts, any contracts that would be covered by 84308, so those could be labor. I think there are a lot of other things those could be as well. I'm not familiar with the breadth of all the kinds of contracts that would be covered by that, but I can try to have a better answer for you next week.
Well, I'm just aware that the original version of the bill had some, I don't know if carve-outs is the right word, but had some provisions with specific application to labor relations. And so I don't know if how this affects that. I was thinking more along those lines. But yes, if you could try to flesh those out, and if we're able to get a little bit more of things are going to happen over the next week, obviously. And so I'm sure for next week's full commission meeting, we'll hear some additional updates. But those are the 2 that I see of interest to me, just how big a exception that could be and having a more practical understanding of that. Thank you.
Certainly.
We're all on the same page in terms of the threshold for triggering this conflict of interest provision. So currently it's 250, right? And Common Cause in their public comment, which I really appreciate them throwing that together, as an excellent analysis of the Dodd bill. They said that they're open to raising it to 500, and then we have Senator Dodd's bill, which would raise it to 1,000, and then we have Ms. McKinner's bill, which would raise it to 1,500. Okay, and then currently under the more general conflict of interest rules, threshold for triggering or potentially having a conflict of interest in terms of giving gifts, that's 590, as I understand it. So currently, you could receive contributions of 250, be precluded from a decision, but you could receive up to $589 in gifts and not be precluded from participating in that decision. Is that correct? And you can kick that one out to Mr. Bainbridge if you prefer.
Sounds right to me, but if that's not, I'll defer to our counsel.
I apologize. I was looking up at something else. So if you want me to answer it, can you please repeat?
Sure. Yeah, the question was about the thresholds for having a conflict of interest under 84-308 versus 87-100. So it sounds like under 84-308, you could have a conflict if you've received contributions of 250 or more from a party, whereas under 87-100, you could receive up to $589 in gifts in the past 12 months and not have a conflict of interest.
Yeah,
To a decision.
that's a correct restatement. I mean, one, we're talking about campaign contributions. The other, we're talking about gift directly to the official. But yeah, those are the correct thresholds.
Okay. So I think that's something that I'm hoping all the parties will consider in deciding how to treat that aspect of the law. Do we have any public comment on this piece of legislation or any other piece of legislation on the update? It doesn't look like we do. Not seeing or hearing any. You can go on unless Commissioner Baker, do you have any other questions on this? Great. So we should know a lot more by the commission meeting. Is that right?
Yes.
Okay.
Yes.
That's good to know. Anything else on this item, Ms. Nakano?
SB 1180. SB 1181. I don't know if I mentioned it's minor and absorbable. SB 1241, Senator Dodd's bill. That bill is on the Senate floor. We had a half position in the legal division. When that bill was heard in the Senate Elections Committee, it was heard April 30th. It passed 4-1 with the chair voting no and Senators Menjivar and Allen not voting. The chair had proposed amendments to remove the carve-outs for certain participants regarding the issue of membership dues, as well as the carve-out for housing development projects. The amendments would have also defined who an agent is instead of removing the aggregation requirement for contributions from agents. And it would also have changed the time period during which contributions are limited to be more time certain in the bill. The author in committee rejected those amendments, but committed to working on the bill with the committee. And Senators Umberg and Newman said they wouldn't vote yes on the floor unless those issues got worked out before in consultation with the committee. So the bill is continuing forward, but amendments are in discussion, and I anticipate those will be happening soon.
Yeah, and me personally, I'm hoping those concerns are addressed because some of those would seriously undermine the rule, in my opinion. Commissioner Baker?
Agree. And just the bill number on that one again?
This is SB 1243, Senator Dodd.
Okay, thank you.
And then do we foresee there being any costs related to SB 1181 once it adopts the amendments that you laid out?
I don't think so. It's creating some minor exemptions, I think what we'd categorize as minor exemptions, and adding a definition. So at this point, I'll consult further with the legal division, but at this point, I wouldn't anticipate additional costs.
Excellent, thank you.
That concludes my updates, but happy to answer questions.
I think we can go on. Oh, Commissioner Baker?
This is about next year because I know that we often use the fall. We keep track of things that maybe didn't proceed this year that we think might be good to continue pursuing. And I'd like to put one out there. I'd at least like to have further conversation in the fall as we're developing our own legislative agenda on the NDA issue, which was AB 2654, I think. I doubt that's the last we'll hear of the subject matter, but I think it raised an issue whether we become an agency that advocates for that or others. But I'd like to put that on our list of topics to revisit as we develop our legislative agenda next year. It's all right. And the other has to do with timing now. So next week is our commission meeting, May 16th, which is the same day as the suspense file. So you're going to have to clone yourself, I'm sure, and be in a couple places. Or we may just actually miss you because you'll be somehow monitoring the very unique suspense hearing that it is. And I'm particularly thinking of Mr. Lowe's bill, Assemblymember Lowe's bill. I want to say it's 2990.
Mm-hmm.
And, it's a great concern that we've already voiced. I know I have. And the costs are significant. So it's possible that it will be held in suspense, but you never know. Suspense is one big mystery sometimes. And we may not be coming back as a commission before House of Origin deadline. And when we may wish to weigh in more directly on a position, we haven't taken a position on that bill. So I would just like to put on next week's conversation, revisiting if we are what we're going to do if it comes off of suspense and we're not meeting again until after House of Origin. And the reason I say that is because House of Origin is when people lock in their vote on a bill number. And it doesn't mean they don't change when it comes back, potentially from the other chamber, but it just makes it a little bit more tricky. And I have strong feelings about that bill. I think it could be a significant impact on us, not only financially, but on the great reforms we've already undertaken ourselves and have made great progress on. So I would like to visit that topic next week. I don't know what we would do. We may have a oppose unless amended, or support if amended, or we may not take a position at all. But I think we need to start planning for that possibility in case it makes it out of suspense and we want to have our voice heard for the full consideration in the Assembly.
I can bring that up for the Commission's consideration next week.
Thank you. Okay, so why don't we move on to, I guess we can ask for public comment one more time. Any public comment? For item 3. Okay, well, let's move on from the legislative update, seeing and hearing no public comment on the update, and we'll move back to the public comment for item 3. Go ahead.
Hello, this is Steve Petzold in Santa Clarita.
Good morning.
I had to give up the Stormy Daniels testimony to speak with you today, but I did make that sacrifice. I want to give Mr. Bainbridge kudos for his expert analysis that he presented today. I may not be in full agreement with him, but certainly he seems to have followed the law. I can tell you that in practice, what we see is a lot of abuse of citizens bond oversight committees. We have a lot of ballot measures coming up, and in every ballot question, in every bond language, it refers to an independent bond oversight committee. And that gives a false sense of security to the taxpayers to think that somebody is actually overseeing the spending of the funds. It's more like overlook committees. They're told to overlook everything. Let me just share with you the recent state at my favorite college, College of the Canyons. Audit of bond spending affirmed. The Santa Clarita Community College District's Independent Citizens Bond Oversight Committee voted to accept the results of an independent audit confirming the district properly accounted for all bond expenditures in the 22-23 fiscal year. That certainly sounds to me as if the chancellor considers them to be advisory, and I can tell you that the trustees largely rely upon the report of the bond committee in making their determination whether to accept the audit. So in practice, they're thought to be advisory, okay? And the voters count on them to have some type of oversight authority over the funds, which rarely, if ever, happens. In fact, they are told in the bylaws that, for instance, reporting administrative or teacher salaries, that they rely upon which is the strict language put in the constitutional amendment and correction, it was Prop 39, not Prop 37. I thought Mr. Bainbridge may have misspoke there. But it says no for administrative or teacher salaries. What happens in practice is that they're forced, they're told they must rely on an attorney general's opinion from 2004 that says that administrative salaries can be paid to the extent that administrative personnel spend time on bond projects. So there, and if anybody ever wants to go outside the box on that, they're told you can't do that. They do not allow minority opinions to go on into the report of Citizens Bond Oversight Committee. Only the majority opinion can be presented by the leader of. So I think in practice, there's a much larger advisory component. And the Citizens Bond Oversight Committees are supposed to report that all spending was in compliance with the
Mr.
California
Benzold,
Constitution.
I apologize for interrupting you. We're coming up against time. Would you mind wrapping up your public comment, please?
I'll wind it up. I think the General Counsel gave a fair presentation, and I look forward to your general meeting coming up here, where we will make further comment. Thank you.
Thank you. And thank you for paying such close attention to this issue. We really appreciate it. One clarifying question for Mr. Bainbridge. Some of the requirements that you provided in your presentation, they're from the Education Code. If we have a committee that's violating their requirements under the Education Code, who would enforce that? It wouldn't, a better question would be, do we have enforcement authority under the Education Code?
No, we don't, and we typically don't even advise on laws outside of the Act or 1090. So our hands are tied in that way, but we certainly don't have any enforcement authority if the individual agencies aren't following what's laid out in the Education Code for how these entities are supposed to be performing.
Thank you for that. And do we know who would enforce that? Would it be the county, the state, both potentially?
I don't know, so I don't want to guess.
Okay. Excellent. Thank you. Comment on that item? No, hearing and seeing none. Let's move on to our last item today, and that's going to be discussion of items for the June 2024 committee meeting. Commissioner Baker, any items that you'd like to add?
Have a particular one? No, thank you. I know we will have a good agenda, robust, riveting.
Definitely. Nothing particular on my end either. Public comment on that item? Hearing and seeing none, I'm going to move to adjourn.
Second.
Excellent. Sasha?
Commissioner Baker?
Aye.
Chair Silver?
Aye.
The motion passes.
Thank you.